Welcome back to our coverage of the Murdaugh murder trial. We're continuing our conversation with trial lawyer Carl B. Grant, breaking down the opening statements from both the state prosecution and the defense today regarding this murder trial. A lot to unfold here. One of the things that had a lot of our viewers talking and commenting today, Carl, they were seeing Alex Murdaugh for the first time, showing emotion since day one of the trial. There were some graphic descriptions of how his wife and his son were found. And at points, he was caught on camera wiping his eyes and hunching over, were the descriptions from reporters inside of the courtroom. How does this hurt or help the case when it comes to the jurors seeing him like that?
Sure. I guess it could be taken either way. All right, the jurors could obviously think that, well, he's feeling sad that his son and wife may have been killed by somebody else. Or on the other hand, they could be thinking, well, I don't know, that's part of the drama of trial. So it could be taken anyway. I mean, who knows what they're thinking in their heads.
Yeah, whether they feel like that was an authentic moment or not, and you'll probably get different answers depending upon who you ask.
Right.
The other thing, Carl, that will be interesting to see, the videos that they reference, saying that the officers who responded had their body cameras rolling, and they asked the jury to pay attention to what Alex Murdaugh says in those videos, to his demeanor in those videos, and they specifically point to the fact that he told, in their words, everybody who would listen, including those responding officers, that he was never at the kennels.
Yeah.
And the defense attorney, Dick Harpootlian, tried to dismiss that by saying, well, they were questioning him in an aggressive manner and he was traumatized. How does that hold up in your mind?
Well, here's the thing. The prosecution was using the old cliffhanger approach. I'm going to dangle something out in front of you for you to see later on and wait till you see this, because this is going to be so important. So that was the approach that he was using there. Now, when it comes to Mr. Harpootlian, and well, he's saying one thing on one hand and one on the other, the jury has to just decide how they're going to handle that. Okay?
The credibility.
That credibility.
Yeah.
This whole case is going to come down to credibility, believability of the witnesses, and applying like I said, the standard of proof, the burden of proof, the presumption of innocence, and following the judge's charges on the law.
Yeah, something else that stuck out to me today, and when you talk about that, the ballistic evidence, where you hear the prosecution saying a family shotgun was used. The spent shell casings were the same as the ones that were found all around that hunting property, where you hear Dick Harpootlian on the defense saying that it could have been a stolen gun. He didn't know who did that. How could that hold up?
Well, again, all of this goes of this goes to how is the jury going to look at this, okay? And I certainly don't want to predict what a jury may do in this case, especially on a case that's still being handled before the court. But the thing is, all the evidence has to be weighed on credibility and believability. Then that applies to both sides, for the prosecution and the defense. The defense does not have any burden of proof or obligation to produce evidence. But here's the point. If you're making an argument before the jury has to determine whether they're going to believe you or not. And if they don't believe you, then they could possibly discount everything that you're saying.
Yeah, they made a lot of promises to the jury today, so we'll have to see if they're able to deliver. I do want to talk about the aspect of picking a foreman for the jury and why that process is important. But before we get to that, when we looked at how things played out in the courtroom today, Dick Harpootlian really, he made a point, as Billie referenced earlier, the gruesome, graphic, horrific images that he described. He painted a picture for the photographs that the jury is ultimately going to see. He also said that when he uses crass language or is possibly offensive to people in the courtroom, to not take it out on his client, to hold that against him. People who have seen and heard from Dick Harpootlian before will not be surprised by an occasional crass statement, but what was he aiming to do there?
I've actually made that argument before. You do not want the jury to hold anything against your client, especially anything that you may say. You may be an aggressive lawyer in cross-examination. You may be going after a doctor in a mid-mal case or a witness in a criminal case. And sometimes you go at them a little too hard, and then the jury is upset with you that you were so aggressive. But you don't want them to hold that against your client. Essentially, what you're telling the jury at that point, I'm simply doing my job.
He's trying to diffuse that before we get to that point.
That's exactly right.
And then to the point about the foreman, explain to us that process and the importance of that role.
Sure. Well, the judge normally appoints the foreman in a trial. And I've often seen where the judge has said, well, you know what, I'm going to let you decide your own foreman. You go back into your liberation room and you vote and tell me who your foreman is going to be. But that is unusual. So in this case, I would predict that Judge Newman would probably appoint a foreman. And the foreman does have some serious responsibilities. He or she has the obligation to sort of be the executive in charge of the jury. Now, their vote is not any more important than anybody else's vote. And they must make sure that each juror has an opportunity to be heard, to be respected, and their positions are respected by everybody, and they get a chance to say what they want to say without other jurors not giving them a chance to speak. And then, of course, he collects the votes and signs the verdict form and everything and reports to the jury.
Yeah. We have about a minute
judge,
or so left. I just want, after everything that we watched today from both sides, what do you think was the most compelling argument made in court today?
I think some of the things brought up by the prosecution about the physical evidence, sometimes it's difficult to deal with physical evidence because it has no emotions, all right? And it either is there or is not. But on the other hand, the defense is going to have their own experts, I'm sure, to challenge some of that physical evidence. So we'll see how it turns out.
All righty. Well, Carl B. Grant will continue to be with us and make sense of everything that we're watching when it comes to the murder trial for Alex Murdaugh. So if you have any viewer questions, make sure to let Judi and I know, and we'll make sure to get that answered for you.